Welcome back to Canadian Justice, where we're discussing the Impact Assessment Act, a piece of legislation some people call the No More Pipelines Law because it makes it so basically impossible that a new pipeline will be built. You know, Brett, we were talking about how the argument here about this, the problem with the law is that the law says, the federal law says it's going to regulate in areas of federal effect, but the concern is that they're actually treading into provincial jurisdiction. And you started making some points in the last segment about what that means. Can you continue what you were saying?
Certainly. So, under the Constitution, the federal government is assigned certain exclusive powers, as is the province. Now, let's just take fisheries as an example, which is under the federal head of power. So, certainly, if you're building a very large hydroelectric dam and you're causing massive disturbances to waterways and fisheries, that's something that would typically be subject to some sort of federal review. Uh, Under the Impact Assessment Act, there's really no way to distinguish between any sort of significant effect or any effect at all. And so it seems that the federal government is attempting to capture, under its jurisdiction, projects that might just be very thinly related to federal jurisdiction. And Justice Rowe actually kept making this point in the Supreme Court case that the mere habitat of a snail could be something that could halt a provincial highway, for example, and really trench into provincial jurisdiction while doing so.
Another thing that a lot of people have commented about this act is what the types of impacts that are considered are. And Brett, can you expand on what they are? I think one of the most famous examples is that the government considers the effect of a pipeline or a mine or a highway on gender. What is the significance of that? And can you explain your concerns around the broad impacts that the federal government's considering here?
Yeah, and from a constitutional perspective, it really is quite problematic. So, as I was saying before, the federal government, its starting point is projects that have effects within federal jurisdiction are subject to this hold. But once the federal government has grabbed a hold of the project, the number of effects that it can consider expands very, very significantly into such things such as the need for the project, alternatives for the project, indigenous knowledge, sustainability, sex, gender, and identity, all sorts of these different factors that bear no relationship to the federal head of power and feed into the ultimate decision on whether the project should approve.
One of the other things I wanted to follow up on is something that I've said a few times in this episode. I've called it the No More Pipelines Law. That's not my term. That's a term that I think the Premier of Alberta, Jason Kenney, had used. I'm sure Danielle Smith, the new Premier, has called it that as well. How accurate is that? Does this legislation mean that there will be no more pipelines built in Canada?
Well, look, the West is experiencing understandable frustration with decades and decades of regulatory uncertainty and frustration of natural resource development. So the Impact Assessment Act is just yet another layer of unpredictable regulatory uncertainty with extremely long timelines. As we were talking about before, factors that make it almost impossible to plan. And it really just introduces a whole new layer of uncertainty, which obviously does dissuade investment. And when you're talking about investment in the billions of dollars, it's very difficult to hedge your bet on a regulatory process that the government can pull the plug on a very thin basis.
So one of the things that you mentioned earlier is this the comment from Justice Rowe at the Supreme Court about the snail habitat, the federal government using their jurisdiction over the environment to stop pipelines or other forms of construction, like even intra-provincial highways, like one highway. But where does the environment fit in our Constitution, in the division of powers? Who regulates the environment?
It's a good question. The short answer is no level of government has exclusive jurisdiction over the environment. And as you can appreciate, Sir Johnny MacDonald didn't exactly envision, carbon taxes and the regulation of snails. in the Constitution. It's a very practical document that attempted for national unity reconciled with regional diversity. So you have very practical heads of powers. Who regulates fisheries? Who regulates canals? Who regulates local works? And so the way the courts have interpreted the environment is, if there is a federal aspect, such as fisheries, or a
Right.
provincial aspect, that's how it's regulated.